afternoon, everyone. Today we embark on an exciting journey into the world of patent law, a field that sits at the intersection of innovation, law, and economic policy. Our topic is unlocking innovation and introduction to patent law. So, patents are not just legal documents, these are the engines that drive technological progress in our modern world. From the smartphone in your pocket to life saving medicines, patents play a crucial role in fostering innovation while shaping global economies. Let's explore this intricate world together. At the heart of every patent lies a fundamental concept, the grand bargain. So, or what we call in legal terms quid pro quo, something for something. This is essentially a social contract between an inventor and the estate. The inventor side, the quid. The inventor must fully and sufficiently disclose their new, useful, and non obvious invention to the public. This is not just a brief description. It must be detailed enough through a patent specification that a person skilled in the relevant field can actually replicate that invention. This disclosure enriches our collective knowledge base and provides the foundation for future innovations. And what is the estate side? The Q. In exchange for this valuable disclosure, the estate grants the inventor something precious, a limited term exclusive right, essentially a temporary monopoly to commercially exploit their invention. This monopoly serves as the crucial incentive that encourages inventors and companies to invest the significant time, capital, and intellectual effort required for research and development. As our Supreme Court has beautifully articulated, the purpose of patent law is to promote scientific research, new technology, and industrial advancement. The price of this monopoly award is the declaration of the invention, which after the fixed period expires and passes into the public domain for everyone's benefit. Coming to the next slide, the nature of patent rights. Now, here is the critical misconception that I want to address immediately. Many people think that a patent gives you the positive right to practice your invention. This is absolutely wrong. A patent confers what we call a negative right, the right to prevent others from making, using, selling, or importing your patented invention without your consent. Think of it as building a fence around your invention, not receiving a green light to use it. For example, you might patent a new pharmaceutical drug, but you cannot legally sell that drug until you have received regulatory approval from authorities like CDSCO, and similarly, you might patent a new automobile component, but you cannot build and sell the entire car without potentially infringing dozens of other patents covering the chassis, transmission, and electronics. Remember, a patent is a right to stop others, not a license to practice your invention yourself. Let me take you through India's fascinating patent journey. The 1856 Act, India's first patent statute based on the British Patent Act of 1852, marked the beginning of our intellectual property journey by granting exclusive privileges. The 1911 Act, the Indian Patents and Designs Act, governed our intellectual property landscape for over 6 decades, reflecting our colonial legal heritage. Post independence transformations. The game changer came after the Iyengar Committee, whose recommendations formed the foundation of modern Indian patent law, reflecting our newly independent nation's developmental priorities. The Patents Act 1970. This was truly a landmark act that balanced the patent protection with our national development needs. Most notably, it allowed only process patents for vital sectors like pharmaceuticals and food, reflecting our commitment to affordable healthcare and food security. This evolution reflects India's journey from a colonial legal system to one that serves our unique national interests. Coming to the next slide, the modernizing Indian patent law post TRIPS. India's integration into the global economy necessitated the significant changes to our patent regime, particularly after joining the WTO, World Trade Organization. The TRIPS agreement on trade-related aspects of intellectual property rights fundamentally transformed India's patent landscape. TRIPS mandated two crucial changes that revolutionized our system. The first one was the obligation to provide product patents across all technology fields. This means we could no longer limit pharmaceutical patents to process patents only. Second, and a minimum patent term of 20 years became mandatory. Standard giving standard to protection periods with international norms. These changes sparked intense debate about balancing innovation incentives with public health needs and debates that continue to shape our patent policy even today. Coming to the next slide. So, defining a patent. The three pillars of patentability. For any invention to receive patent protection in India, it must satisfy three fundamental criteria under Section 21J of the Patents Act 1970. Think of these as the three pillars supporting the entire structure of patentability. Pillar 1, the novelty. The invention must be entirely new and not part of existing public knowledge anywhere in the world. We call this existing knowledge prior art. The novelty test is global and absolute. If someone in Japan published your idea yesterday, your application today fails the novelty test. Pillar 2, inventive step. This is often the most contentious criteria. The invention must not be obvious to a person skilled in the art, a hypothetical person with ordinary knowledge in the relevant technical field. This requires genuine ingenuity, not just routine engineering or obvious modifications. Pillar 3, the industrial application. The invention must be capable of being made or used in the industry. This excludes abstract theories or mathematical principles. Einstein's E is equal to mc square was a profound discovery, but it was not patentable. However, a nuclear reactor applying that principle to generate energy would be patentable. These three pillars work together to ensure that only genuine innovation and particularly useful inventions receive patent protection. Coming to the next slide, the core patent principles. Three fundamental principles govern all patent systems. Time limited protection. Patent monopolies are never perpetual. In India, consistent with international standards, a patent term is 20 years from the date of filing. After this period, the invention enters the public domain, allowing anyone to use it freely. Territorial nature. Patent rights are strictly territorial, and Indian patent provides protection only within the Indian borders. For global protection, inventors must file separate applications in each country where they seek protection. Product versus process distinction. Protection can cover the product itself regardless of how it's made or solely the specific manufacturing method. This distinction has profound implications for industries like pharmaceuticals, where process patents allowed generic competition while product patents prevented it entirely. Coming to the next slide, what cannot be patented? Statutory exclusion. Even meeting the three pillars does not guarantee a patent. Section 3 of our Patents Act excludes several categories, reflecting India's unique public policy goals. Number one is frivolous inventions or those contrary to natural laws. Okay. Second one is abstract discoveries or scientific principles. Third one is new forms of known substance lacking inherent efficacy under the section 3D. And fourth one is medical treatment methods for humans. And fifth one is computer programs per se, abstract algorithms or computer programs themselves. Section 3D deserves special attention as it prevents evergreening, the practice of making minor modifications to extend the patent monopolies. Coming to the next slide of global patent frameworks. Indian patent law operates within a broader international framework shaped by key treaties. The The Paris Convention of 1883 established the crucial right of priority, allowing 12 months to file internationally while retaining the original filing date. The Patent Cooperation Treaty (PCT) of 1970 streamlines international filing through a single application system. The TRIPS Agreement of 1995 sets minimum intellectual property protection standards, mandating product patents and 20-year terms globally. Landmark, coming to the next slide, landmark case study of Novartis versus Union of India. Let me conclude with a pivotal case that exemplifies these principles in action. The dispute was that the Novartis sought a patent for a new crystalline form of Gleevec, their anti-cancer drug, arguing improved bioavailability made it patentable. The Supreme Court's ruling. The Supreme Court denied the patent interpreting efficacy in Section 3D as therapeutic efficacy. Improved bioavailability alone was insufficient. They needed to prove better therapeutic outcomes. The significance of this case was that this judgment upheld the Section 3D as a safeguard against evergreening, affirmed India's commitment to public health and affordable medicines, and set a high bar requiring genuine therapeutic benefits for pharmaceutical patents. This case perfectly illustrates how patent law serves as a tool for economic and social policy, balancing innovation and incentives with public welfare. Coming to the conclusion, uh, as we have seen today, patents represent far more than simple registration mechanism. They embody a complex social contract that balances innovation, incentives with public access, territorial sovereignty, and with global integration and economic development with social welfare. Understanding these principles is crucial as we delve deeper into the patent law. The journey from India's 1856 Act to our modern TRIPS compliant system reflects our nation's evolving relationship with innovation, technology, and global economic integration. Thank you for your attention.